Welcome to everybody to this session of this year's ASIL conference, the session on the Arbitral Tribunal knows the law. This event will tackle a question that has attracted attention of both scholars and practitioners for some time now, namely that of whether arbitral tribunals may develop their own legal reasoning independently of the agreement and pleadings of the parties. Something that to us may be an oxymoron, given that arbitration itself is considered to be nothing but the result of manifestations of party autonomy, at least according to the mainstream understanding of arbitration. That party autonomy is unlimited in arbitration is often repeated and taught, but it has never fully convinced scholars. Scholarship has shown that there are limitations to party autonomy in arbitration. This is in line with general teaching, but it does not want to deny the importance of party autonomy, nor is what I just said based on antiquated theoretical approaches. Quite to the contrary, in my opinion. For the sake of arbitration itself, it is important to understand how far party autonomy can reach in arbitration. When drafting a contract, a too optimistic understanding of party autonomy may lead to contract terms that will not be valid or enforceable. Drafters may be induced into feeling safe, a feeling that may turn out to be unrealistic and result in unnecessary surprises, which could have been avoided if the understanding of party autonomy had been realistic. When writing an award, a too optimistic understanding of party autonomy may lead to awards that violate fundamental principles of the country where the award is rendered or shall be recognized or enforced. Also, arbitrators who are aware of the risk that their award may be annulled or refused recognition or enforcement may be reluctant to interfere with the contract terms or the party's choice of law out of fear to exceed their powers or to violate principles of due process. These scenarios can be encountered in practice. A realistic assessment of the legal framework as well as the limits to party autonomy is, in my opinion, necessary to allow the parties to take full advantage of arbitration as a mechanism to solving disputes in an efficient way. Today, we will examine the question of whether Iura Novit arbiter is a principle relevant in this context within the aforementioned goals and within the framework given. This is the lens through which I suggest you look at this event. In other words, the parties' arbitration agreement and pleadings set the scope for the power of the arbitral tribunal. One has to wonder, however, whether when developing its legal reasoning, arbitral tribunals are necessarily bound to follow exclusively the parties' instruction. To answer the question, it will be necessary to take into account the arbitral tribunal's leeway in the sense of the arbitral tribunal's possibility to rely on the principle of Iura Novit arbiter. This requires one to determine whether the various countries, the law of which may become relevant in one and the same arbitration, embrace the principle Iura Novit arbiter, and if so, to identify the exact contours of the principle. And it is my colleagues, Ndanga Kamau, Sui Yen Ko, Rafael Alves, and Philippe Pensol, who will trace these contours today. Allow me to briefly introduce them in the order they will give their presentations, focusing on various African legal systems, Singapore and China, Brazil and Argentina, and on due process and its relationship to Iura Novit arbiter, specifically in Switzerland and in France, respectively. Ndanga is the founder of Ndanga Kamau Law, an international practice based in The Hague. She sits as arbitrator and acts as counsel in institutional and ad hoc arbitration. Prior to setting up her own practice, she worked in international law firms in the United States and in Switzerland, and was a registrar at an arbitral institution in Mauritius. She is a vice president of the International Court of Arbitration of the ICC, president of the ICC Africa Commission, and co-chair of the Africa Group of the IBA Arbitration Committee. Sui Yen is a partner in the commercial and corporate disputes and international arbitration practices of Wong Partnership LLP. She was a former vice chair of the IBA Arbitration Committee. She is currently the vice chair of the IPBA Dispute Resolution and Arbitration Committee and a member of the editorial board of the ICC Dispute Resolution Bulletin and the ICCA ASIL Task Force on Damages. Sui Yen is highly recommended for expertise in resolving complex international disputes by various legal publications. Now, Rafael is a partner at MAMG Abogados, professor of Fundação Getúlio Vargas in São Paulo, FGV Law. He is a council member of CPR and co-chair of the Brazilian Advisory Board. Rafael is also a director of the Brazilian Arbitration Committee, CBAR. He is a former deputy counsel at the Secretariat of the ICC in Paris. He holds a Bachelor of Laws, Master of Laws, and PhD from University of São Paulo, and of course an LLM from NYU, where he was an Arthur Vanderbilt Scholar and actually also the recipient of the Arthur Vanderbilt Medal in 2010. Philippe is the head of international arbitration for continental Europe of Queen Emmanuel. He has acted as counsel in more than 270 international arbitrations, with a particular focus on investor-state arbitrations and commercial disputes involving the energy, power, oil and gas, construction, and defense industries. Philippe is a current co-chair of the IBA Arbitration Committee. He is also a member of the Court of Arbitration of Singapore International Arbitration Center, the SIAC, and an advisor of the International Advisory Board for the Thailand Arbitration Center, TAC, of which I am actually the president. In 2020, Chambers Global ranked Philippe Band 1 for both Europe and global-wide international arbitration. This by way of short introduction. I'm sure, and you know the colleagues who will be speaking today, that there are many other things to be said, but time does not allow that. Before giving the floor to Ndanga, allow me to say that after this event, it will be possible to actually go on, talk to us, and continue the conversation. Now, Ndanga, I give you the floor for the next 10 to 12 minutes, please.
Thank you very much, Professor Ferrari, and thank you to ASO for having me to join this panel for this very interesting discussion. Now, as Professor Ferrari has already mentioned, I thought that I might give a flavor of the Iura Novit Curia as it's recognized in the African context. And before I give those examples, I thought I might make 3 preliminary remarks. Now, the first is that when one tries to track the contours of anything in Africa, it's obviously important to start off by recognizing the diversity of the continent and the diversity of the jurisdictions, so that any statements that you make are obviously, very aggregated and should be taken as that. Now, what we see across the continent is a modernization of arbitration laws and the institutional framework for international arbitration. So we can use this as a mechanism for identifying the trends that allow us to make some generalizations about what's happening on the continent. Now, this modernization has been happening only in the last, I would say, 15 years, to the extent where we can say that there is a trend towards the modernization of laws and institutional framework. So what we're seeing, that it's only now that judiciaries across the continent are starting to grapple with questions, fundamental questions of international arbitration, such as those that the professor has already mentioned: party autonomy, finality of awards, and even this question of Iura Novit Curia. So we're seeing that judiciaries are grappling at the stage of set aside and enforcement with questions of the excess of powers by the tribunals, as well as these questions of due process, which we will hear in more detail when Philippe makes his interventions. So that's the first point with respect to really to the diversity that we see across the continent. The second point is that when we talk about legal systems in Africa, we inevitably are confronted with the colonial histories of these jurisdictions, because those colonial histories have shaped the way that these legal systems have developed and have determined the way in which some of these principles, such as Iura, Novit, Curia, are understood in the domestic context. And we see the range of legal histories from French civil law, we see some Belgian civil law, we see even some German civil law, and of course the common law. And we even see Roman Dutch law in the southern part of Africa, in South Africa, Namibia, and other jurisdictions. So even though we are seeing a harmonization of laws across the continent, these histories will impact the way in which, one, tribunals themselves feel comfortable or not comfortable to go beyond what the parties themselves might have put before them. And secondly, in the way that judges themselves will deal with these issues when they're confronted with the questions of setting aside or enforcement. So we must always remember that the colonial legal histories remain relevant today. Now, the third point is that we see a dearth of reported cases in Africa dealing with arbitration questions. So it's very difficult to determine from the practice of the courts themselves what developments are actually being made on some of these principles that are relevant to arbitration, including Iura, Novit, Curia. So that's by way of the preliminary remarks. Now, on to the examples where we see the recognition of Iura, Novit, Curia. And here I'll do it in two parts. The first is to look at where it appears in arbitration laws, and the second is where we see it appearing in arbitration rules. So with arbitration laws, we start in Tanzania. Now, what's interesting about the Tanzanian Arbitration Act is that it's a reproduction of the English Arbitration Act 1996. And Tanzania enacted this law in 2020, so it's still a young, new, untested arbitration law, but contains most of the provisions that are contained in the English Arbitration Act, for better or worse. And here we see that Section 36G of the Tanzanian Act is a direct copy-paste of the English Act. And here we see that the arbitral tribunal shall decide all procedural and evidential matters subject to the agreement of the parties, including whether and to what extent the arbitral tribunal shall itself take the initiative in ascertaining facts and law. So we're seeing it's not just ascertaining the law, but also ascertaining facts. And this is as is known, is well known, is a peculiarity of the English arbitration system, which we don't find stated in such clear terms elsewhere, but we now see in Tanzania by virtue of its adoption of the English Act. It remains untested, so we'll see how this is practiced by both tribunals as well as the judiciary. A second example is found in the OHADA Uniform Arbitration Act. And we don't have time to go into the OHADA system, but this is a remarkable effort at harmonizing business laws across Africa. It includes 17 African countries, mostly from the French-speaking part of Africa, but also includes Portuguese-speaking and the one Spanish-speaking African country. And here we see, again, a clear statement on the tribunal having this power to go beyond what the parties have selected. And here it says that the tribunal can apply, where the parties haven't chosen, the law that it considers most appropriate, taking into account international trade, customs and usages. So that's the OHADA Arbitration Act. And here we see the extent of the OHADA region gives us an idea as to the extent of the recognition of this principle. So within one law, we capture already 17 African jurisdictions. Now, moving to the arbitration laws, again, we see here that it's a story of the adoption of other arbitration rules in the African context. So we see that arbitration centers in Africa have adopted rules that are based on the ICC rules, the LCIA rules, and the UNCITRAL rules. Now, starting with the ICC rules, we see the adoption of rules that are ICC-based in Rwanda, and this is by the Kigali International Arbitration Center, which has within its provisions in Article 27 an applicable law that in the absence of an agreement by the parties, the arbitral tribunal shall apply the rules of the law which it determines to be appropriate. So we're starting to see here, again, within the arbitration rules, this recognition that the arbitral tribunal can go beyond the realm that the parties have put before it. We see a similar adoption of ICC-based provision at the Casablanca International Mediation and Arbitration Center in Morocco, which uses wording that's virtually the same. Again, here recognizing that the tribunal can go beyond what the parties have chosen or in the absence of the parties choosing. A third example we see that uses the ICC base is, again, the OHADA arbitration rules. Now, the OHADA system contains both a framework for harmonization of business laws, but also has a separate arbitration center. So the Common Court of Justice and Arbitration in Abidjan is both a supranational court, which, for example, is charged with questions of set-aside of OHADA arbitration awards, as well, and enforcement questions, as well as acting as a separate arbitration center with its own rules. And here again, we see a provision in Article 17 of the OHADA arbitration rules that provides for the tribunal to apply the law that it determines it would be appropriate in the circumstances. Another set of arbitration centers in Africa has based its laws, or its rules rather, on the LCIA rules. And here we see the embodiment then of what would be Article 22.3 of the LCIA arbitration rules appearing in the arbitration rules of the Nairobi Center of International Arbitration in Kenya. And here again, the wording is similar, where we see that the arbitral tribunal shall apply the law or rules of law which it considers appropriate. And again, in South Africa, we see the Arbitration Foundation of South Africa that has adopted rules based on the LCIA rules, which uses the same wording, again, what it considers to be appropriate. Finally, we see a set of institutions that has adopted the anti-trial rules. And here, of course, you'll be familiar with Article 35 of the anti-trial arbitration rules. The examples here we see in Nigeria, where the LCA, the Lagos Court of Arbitration, has rules, Article 37 on applicable law mentions that the arbitral tribunal shall apply any law that it determines to be appropriate. And again, in the LASIAC, which is also in Lagos, similar wording on what the tribunal considers to be appropriate. Now, this is, of course, a very high-speed canter through the continent, but the idea is to give you a flavor of what is happening on the continent and to see that indeed there is a recognition of this principle in the African context, although we may not be able necessarily to see the actual application by courts on the application of these recognition or not of the principle of Iura or Novit, Curia. So what can we say in the last few seconds that I have about prospectively what we expect to see? I think what we will see is that the jurisdictions in Africa, as they test their arbitration laws, will rely on the developments in other jurisdictions. And we've seen that, for example, the Kenyan judiciary is very open to doing a comparative analysis of the application of the anti-trial model law, turning to jurisdictions such as Singapore, which we'll hear about in a moment, which have more established practice on these principles. So in a nutshell, these are jurisdictions to watch. Thank you very much, and I'll stop there, Professor Ferrari.
Thank you very much. And again, sorry to have you run through all of this information so quickly, but thank you very much for keeping track of time as well. This being said, the situation in Singapore as a model for some of the countries you referred to, Ndanga, has been mentioned, and I give the floor right away to Suijin.
Thank you, Professor Ferrari. And thanks for the very kind introduction. I would also like to thank ASIL for inviting me to join this panel. I would like to examine this doctrine of Iura Novit arbiter, first looking at Singapore's approach to it, and then contrast this with the approach that may be taken by the PRC courts, because that is a civil law jurisdiction, and end off to perhaps give some concluding remarks as to whether there would actually be a difference in approach depending on whether it's a common law or civil law jurisdiction. And my conclusion would ultimately be probably there isn't a difference in approach because of that. First and foremost, if I speak about the Singapore approach to Iura Novit arbiter, I think it is in line with its pro-arbitration policy of minimal Curia intervention. An arbitral tribunal is accorded with very broad powers and latitude in the handling of the arbitrations. The broad powers that are given to an arbitral tribunal can be found in the arbitration legislation of Singapore. So if we were to look at the International Arbitration Act, you can see the powers granted to the tribunal, other than granting interim relief, security for cause. It extends to the powers given to the tribunal to grant any relief that the High Court of Singapore would be able to grant. What is even more interesting is that Singapore, despite being a common law jurisdiction, known as having an adversarial system, has a legislation in the International Arbitration Act, specifically Section 12(3), which provides that an arbitral tribunal has the power to adopt, if it thinks fit, an inquisitorial approach. This is very interesting and may come as a surprise to some participants who may be thinking, that's odd for a common law jurisdiction. But this is actually statutorily provided for. What we also see is that the broad powers that is given to an arbitral tribunal under the arbitration legislation has also found its way into the rules of major institutions. In the interest of time, I just want to cite from the Singapore International Arbitration Centre rules. Rule 27 specifically speaks about additional powers of the tribunal. Rule 27A says that the tribunal has the power to order the correction or ratification of any contract subject to the law governing the contract. Rule 27C, similar to Section 12(3) of the IAA, provides a tribunal may conduct such enquiries as may appear to the tribunal to be necessary or expedient. Rule 27M further provides that the tribunal may decide, where appropriate, any issue not expressly or impliedly raised in the submissions of a party, but there is an important proviso. Provided such issue has been clearly brought to the notice of the other party and that other party has been given adequate opportunity to respond. And that, I say, is the limit to the principle of Iura Novit arbiter. That while the tribunal knows the law and would draw the necessary inferences from the law, what the tribunal must always ensure is to ensure due process, which I'm sure Philip will touch on further, ensure that the rules of natural justice are observed, and ensure that the tribunal is not acting in excess of power. And in my view, this is rightly so and the right position, because arbitration is ultimately founded on parties' consent. While a tribunal can consider facts, law, and even issues not pleaded by the parties, at the very bare minimum, I believe that the parties must be given a reasonable opportunity to be heard on these matters, failing which there's always a risk that the award may be set aside or refuse enforcement. I would just like to illustrate this with a quick example from a 2016 High Court decision of JVL Agro Industries and Agri-Trade International Trade Private Limited. In that particular case, the High Court had actually set aside an arbitral award on the basis that there was a breach of natural justice because one of the parties had been deprived its opportunity of presenting its case. The case is very simple. The plaintiff was claiming damages for breach of certain unperformed contracts. And the defendant's defense was there was a price averaging arrangement under the contract, and this was too uncertain to be enforceable. In the evidential phase, the tribunal directed the parties to address it on the parole evidence rule and its exceptions. The tribunal then asked the parties specifically to deal with a collateral contract exception, but none of the parties dealt with it. Ultimately, the tribunal's decision that the price averaging arrangement amounted to a collateral contract, which was in law capable of varying the parties' performance, became the very foundation of the decision. And this was determinative of Agritrade's liability to JVL for breach of contract. So the High Court, when this case came before the High Court for setting aside, the High Court specifically cited Section 12.3 of the International Arbitration Act, which I started off this presentation with, where they said, notwithstanding the inquisitorial process that any tribunal may adopt, it is not for the tribunal to raise an issue of its own accord at the 11th hour and in passing, and then decide on that issue without giving the parties the right to present evidence or submissions on this issue, or without directing parties to address that issue. The High Court therefore found that the tribunal had impermissibly relieved the winning party of its evidential and legal burdens of proof and was exercising unreasonable initiative. I just want to pause here to add my personal observations. This, I believe, is the right decision. We often see situations where the tribunal really starts delving deep into the dispute and the issues right before the start of the evidentiary hearing. The issues and the facts crystallize when the parties present their opening statement. During the evidentiary hearing, the tribunal hears from the parties and looks at critical and key documents. During the cross-examination of the witnesses, the tribunal starts to ask questions. At the close of the evidentiary hearing, the parties put in their closing submissions. The tribunal starts to read them, starts to consider the hearing, and starts to deliberate. And that, I say, is when the issues really start to crystallize and all come together for the tribunal. And if at that point in time, the tribunal finds that there's a particular issue that concerns the tribunal that is material to the decision, what is it that is stopping that tribunal from reaching out to the parties at that point in time, even after the close of the evidentiary hearing, to say, this is an issue that the tribunal is considering, and to give the parties, both parties, an opportunity to make submissions on that issue. And that, I feel, is something which tribunals should do more of. And in fact, I think if tribunals actually do that, it is consistent with the principle of Iura, Novit, arbiter. Because the tribunal is still thinking and still the one who knows the law and who's thinking this is something that is material to me in coming to this decision. But what is important is that the tribunal gives the parties an opportunity to make submissions on that. And that, I believe, is the right balance that we hope to see in the cases. And I have to say, when you look at the entire Singapore jurisprudence, other than that case that I mentioned of JVL Agro, it is often the norm that setting aside applications and applications to resist enforcement on the grounds of breach of natural justice are unsuccessful. With the word may, where a court may refuse enforcement, a court may set aside an award, you will find many instances where even if there was a breach of natural justice, if a party is not unduly prejudiced by that breach of natural justice, the award will not be set aside, the award would not be enforced. What fundamentally the courts have come down to is, we do respect the tribunal has the mandate, unless there is a dramatic departure from what has been presented by the parties, we will not interfere. And I think that creates a fine balance and respects the principle of party autonomy, as well as respects the principle of Iura, Novit, arbiter. In a very short 1-2 minutes, as I note that the time is slowly and quickly taking away, I just want to touch on the position of China, because it is a civil law jurisdiction, Japan, Korea, other civil law jurisdictions in Asia. And I think from China, what we can draw from is that if you look at the provisions on the Supreme Court on evidence in civil procedure, it is very clear that the judges do take an inquisitorial approach, where in the course of the litigation, if they come by a certain situation where they feel that the nature of the legal relationship or effectiveness of the civil act is inconsistent with the determination that they make on the facts, they should actually take the initiative to try the nature of the relationship or the effectiveness of the civil act. So from that very broad general rule, you can see that the courts have adopted this approach of an inquisitorial process. So how does this then translate to a situation where how do the courts view the tribunal's powers in, administering the arbitration? I would say that they would view the powers of the tribunal in the very much same way that the tribunals have the powers to adopt that inquisitorial approach. That being said, I still reach the conclusion that it would not be any different from, for instance, what Singapore is doing. Because even in our arbitration legislation being a common law adversarial system, we still give the tribunal that power to adopt the inquisitorial approach where it deems fit. At the end of the day, the right balance is, yes, we recognize Iura Novit arbiter, but please ensure that you give the parties an opportunity to make submissions. Thank you.
Thank you very much, Sui Yen, not only for the information, but for being very clear. And what I like, of course, for putting forth your point of view, which I think is being shared by the colleagues here. Raphael, it is your turn now for up to 12 minutes.
Thank you, Professor Ferrari. And thank you very much, Andrea Burgi, for the kind invitation, as well as the American Society of International Law. It is always a pleasure to share this panel with my colleagues, Danga, Sui Yen, and Philippe, and revisit this subject on Iura Curia in arbitration, which was one of the core topics of my PhD dissertation, and also my contribution with a chapter on Brazil to a book organized by Professor Ferrari and Professor Cordeiro Moss on the same topic. I will briefly address this topic of Iura Curia in arbitration under Brazilian law today, as well as some comments on Argentinian law in the end. So in Brazil, there's no express regulation of Iura Curia in arbitration. So one needs to turn to general principles and rules under the Brazilian Arbitration Act, and also case law to understand how this issue has been dealt with lately. I divided my presentation into two parts. First, foreign arbitral awards, and second, domestic arbitral awards. According to Brazilian law, if an award has been rendered within the Brazilian territory, for instance, the place of arbitration is a Brazilian city, it is a domestic award. Otherwise, it is a foreign award. First, with respect to foreign arbitral awards, Brazil has adopted the New York Convention since 2002, and since 2004, the Superior Court of Justice, known as the STJ, has been the competent court to decide on the recognition and enforcement of foreign awards in Brazil. So far, the STJ has been doing a very good job in correctly applying the provisions of the New York Convention and also the Brazilian Arbitration Act, with very few exceptions. On the specific topic of Iura Curia in arbitration, the STJ decisions dealing with fair hearing and procedural guarantees in exequatur of foreign awards do not provide specific guidelines as to how an arbitrator should conduct the proceedings or to what extent he or she is empowered to apply the law on its own motion. On the other hand, with respect to excess of powers, there is an important precedent which is on public domain. Attack Management versus Rodrimar. In such precedent, the STJ granted the recognition of a foreign arbitral award in which the sole arbitrator had decided the case based on the CISG. According to the report, the contract provided for Swiss material law as the applicable law, and the sole arbitrator understood that the reference to Swiss material law contained in a contract for the international sales of goods should be interpreted as the application of the CISG as part of Swiss law, unless the parties had excluded the CISG, which did not occur in such case. Apart from the choice of Swiss law, one of the parties was a German resident and the other a Brazilian resident. According to Rodrimar, the party resisting recognition of the award, by applying the CISG, the sole arbitrator acted in excess of powers, and thus recognition of the award should be denied. The STJ rejected Rodrimar's allegation, including on excess of powers, mainly because the court understood that it cannot review the merits of the arbitrator's decision, particularly with respect to the applicable law, and that there had been no violation of public policy. In such regard, Justice Nancy Andrighi emphasized that in an exequatur proceedings, the STJ cannot replace the arbitrator or second guess how Swiss material law should be interpreted or applied. In addition, Justice Nancy Andrighi also clarified that by choosing Swiss material law, parties have waived their rights to the application of their own domestic laws, and in international arbitration, nothing prevents them from doing so under Brazilian law. Now, turning to domestic awards, the Brazilian Arbitration Act provides the arbitrator with broad powers to decide on the applicable law as well as to decide on the merits of the dispute. Such broad powers encompass the power to apply a source, a legal basis, or a legal reasoning, which may differ from the ones brought by the parties, subject to some caveats, which I will explain further on, mainly related to the limits of the arbitration agreement and the parties' procedural rights, failing which the award may be subject to set-aside proceedings according to Brazilian law. An arbitral award is not subject to appeal under Brazilian law and may not be reviewed on the merits by the courts. The grounds for setting a domestic award aside are very limited and narrow in Brazil, and courts apply them only sparingly. Article 22 of the Brazilian Arbitration Act establishes two grounds for setting a domestic award aside, which could be related to Iura arbiter. First, when the award falls outside the limits of the arbitration agreement, which can also be interpreted as excess of powers. And second, when a party did not have a fair hearing or had been deprived of the right to present its case or to defend itself, which under Brazilian law is also called contraditório, the adversary principle. First, with respect to excess of powers, under Brazilian law, as a general rule, an arbitrator should not go beyond what the parties have expressly requested and claimed, that is, prayers for relief, including the remedies. An ultra petita award, as well as an extra petita award, may be set aside under Article 32 of the Brazilian Arbitration Act. While arbitrators may not go beyond what the parties have expressly claimed or requested, he or she may grant such request with a different legal reasoning, different from what the parties have alleged, as long as parties have not linked their claim to a specific legal ground or legal reasoning in the arbitration agreement or in the terms of reference, and as long as due process guarantees are respected, basically not taking the parties by surprise and respecting their right to be heard, which as I will detail shortly. This understanding has been recently confirmed by STJ decisions. According to the STJ and also to some Court of Appeals in some Brazilian states, such as the state of São Paulo, for instance, the principle of Iura Curia applies in arbitration under Brazilian law with some limitations. So it would be wrong to assume that in Brazil, an arbitrator could simply disregard the parties' pleadings on legal issues and be guided by Iura arbiter alone, without any additional caution. The most reasonable approach and interpretation of the Iura arbiter does not favor a broad application of such principle under Brazilian law, but a limited one. Now, turning finally to due process guarantees. Under Article 32 of the Brazilian Arbitration Act, an arbitral award may be set aside whenever four principles contained in Article 21, second paragraph, are violated. Parties' equality, the adversary principle, arbitrators' impartiality, and the arbitrators' freedom of judgment. Out of those principles, the adversary principle, or the right to be heard, is the one related to the discussion on Iura arbiter. One of the main features of the adversary principle in Brazil is the avoidance of surprises to the parties. In principle, a decision should not take the parties by surprise. On the other hand, it would be unreasonable to assume that an arbitrator should hear the parties in advance for each and every of its decisions under Brazilian law. For instance, it may occur that the parties had all the elements present in the case files to make a specific submission on a specific issue, but they chose instead not to do so. Under Brazilian law, the respect for the right to be heard does not mean necessarily the actual exercise of the parties' right to be heard, but the possibility to do so. Fair hearing means that the parties had the chance to make submissions and produce evidence they deemed necessary. If they fail to do so, they should bear the consequences of their burden. And in any event, to be sure, arbitrators may always ask the parties to comment on specific legal provisions or legal bases not discussed before the arbitrators actually render a decision about it. In my view, under Brazilian law, arbitrators may, but are not obliged to do so, to determine the applicable law, absent the parties' express choice, as well as to correct legal sources, legal bases, and legal reasoning on their own motion, meaning ex officio, as a matter of the applicability of Iura Novit arbiter. They may do so as long as the parties have not expressly prohibited them from doing so beforehand. In any event, arbitrators should exercise caution and avoid surprises to protect due process guarantees. One final comment, Professor Ferrari, 1 minute, regarding Argentinian law. My understanding is that there are precedents rejecting challenges against awards which relied on a different legal ground other than the one presented by the parties. So like in Brazil, Argentinian courts also tend to accept, in principle, the application of Iura Novit arbiter in arbitration, within certain limits. As explained by my colleague Julio César Oliveira in a recent article on this topic, the exercise of Iura Novit Curia powers in Argentina are limited, for instance, by the constitutional principle of congruence. So in Argentina, arbitrators may not render an award on defenses not pleaded, or modify factual basis of the parties' submissions, or grant remedies different from the ones sought by the parties. Thank you very much, Professor.
Thank you very much also for indicating what may happen if the arbitrators do indeed apply the principle and do not guarantee what you and also Sui Wen have referred to, meaning that right to be heard by both parties on that specific issue. With that, I give the floor to Philip.
Thank you very much, Franco. Thank you, everybody. The court knows the law, Iura Novit Curia, the arbitrators know the law, yet the collision of this principle with the principle of due process can tell us a lot, actually, about what this principle is about. And just to illustrate that, I would like to start by looking at two jurisdictions which are close, France and Switzerland, not only close geographically, but close in terms of civil law tradition and close in terms of being arbitration friendly, probably the most arbitration friendly in the world. And nonetheless, they came to, I would say, almost opposite conclusions on this. Starting with my own system, the French system, one can say that the principle Iura Novit Curia is almost entirely swallowed by due process. And the reason for that is that the Court of Appeal in Paris, supported by the Supreme Court, the Court of Cassation, has consistently held that nothing that serves as a ground for the arbitrators to reach their decision, be it in law or in fact, can escape the debate between the parties. So that principle is very broad and would place on the same footing law and fact, as you've seen. And as a result, if ever you apply Egyptian law and the Civil Code of Egypt, but you don't apply a part that was pleaded by the parties, your award will be set aside. If one party is asking for lost profits, but instead of giving lost profits, you give the loss of an opportunity to make profit, which is different cause of action, your award will be set aside. If you start applying a different interest rate that you calculate on your own without asking the parties, your award would be set aside on that. And even if you allocate costs by applying an obscure rule of Austrian law that nobody has ever pleaded, your award will be set aside. So in essence, whatever you decide and the manner in which you decide it, if you sit in France, you have to ask the parties to give their views on it. You can do whatever you want, but make sure that the parties give their view. If you cross the border and you go to Switzerland, the situation apparently is much easier for arbitrators because the principle of Iura Novit arbiter applies fully, and the Federal Supreme Court has said consistently that arbitrators didn't have to let's say, take the same precautions as in France, and they could apply the relevant rule to solve the dispute. That is the principle. There is, of course, an exception, and the exception is narrow but important, is that the arbitrators cannot apply a rule which the parties could not even think about, could not even consider it could apply to the dispute. It's a narrow exception, which I believe was applied in 2 or 3 occasions. One case was a factual situation where the parties were arguing whether the contract was void, and the arbitrators held that one could terminate it, which was not argued. And the other one, which is reported, was about, again, the validity of an exclusivity clause, and the arbitrators had resort to employment law to resolve that issue, even though neither parties had argued it. So you have the situation where the principle of Iura Novit Curia applies, but nonetheless, due process is there. And if ever you want to depart completely from what the parties argued, you are better off asking them. And the reason for that is that even though the exception is applied narrowly, it could apply to you. So if you take some distance and you ask yourself, well, what should I do in those circumstances? What is the best course of action? What I would put to you is that you are always better off asking the parties. And with this, I will side with Suyen and her explanations, is that there are at least 4 reasons, in my view, why, regardless of what is the technical solution at the seat of arbitration, you should ask the parties. The first is that, as we say, arbitrators have no forum. So the notion that you could know the law is very much linked to sitting in a place where the law applies. And I would say that this philosophical foundation does not apply. The second reason is more pragmatic, is that very often you will find a tribunal comprised of members coming from different legal traditions, and none of them may be familiar with the applicable law. That happens frequently. And as a result, there is a bit of, let's say, artificiality in saying that they know the law. The third reason is even more pragmatic, is that the practice of international arbitration is such that law is treated as fact and pleaded as fact, very often with expert opinions and the like, perhaps on account of the fact that the members of the tribunal may not be familiar with the law. And the last one is really the real one, and the most pragmatic one, is that you have nothing to lose because you don't know where your award will be enforced. We do know that various jurisdictions have different views on this, and as a result, if ever you ask the parties for their views prior to making your decision, you're on the safe side in terms of enforcement. And so these considerations, in my view, should lead you to, let's say, be cautious, even though you want to resort to Iura Novit Curia, and you are entitled to do so in the jurisdiction where you sit. So that's the technical background, if you want. And as I said, due process will tell you how to do it if you want to do it, making sure that the parties express their views. But there is a more fundamental issue that I would like to discuss, is whether you should do it at all. The question is, yes, I am the tribunal. I know the law. I can apply the law. Now, question is, should I do it? And here you have 2 competing concerns, and which are relevant for your decision. The first concern is your neutrality as tribunal, is that when you realize that a given norm, a given rule could solve your dispute, and that rule was not argued by the parties, that rule will likely produce an effect in favor of one of the parties. And of course, you will give an advantage to that party and a corresponding disadvantage to the other party. Making that decision is not obvious as a tribunal. You realize that there may be a solution which is not pleaded, there may be a reason for that, but before even asking the parties about their views, you should ask yourself whether this is the proper course of action. And this is the limit, in my view, of the Iura Novit Curia rule, or Iura in particular, when it comes to applying a clause of a contract that the parties have not pleaded. Is it really the law that you're applying, Or are you making the job of one of the advocates of the parties? Because that's not the law. That's simply looking at the contract and finding a clause which might result in the solution being in favor of one of the parties. So one query, and I don't propose to give an answer, is that when you do that, or when you feel like doing that, are you really doing Iura Novit Curia or something else? The competing concern, of course, is international public policy. If both parties come to you with a contract for drug trafficking and ask you to enforce that contract, and neither party is pleading the fact that that contract could be void under the applicable law, which will generally be the case, will you enforce that contract? Will you not ask the parties to give their views about the validity of the contract? Of course you will, because you know that there will be a court which may look at it afterwards. Well, in a case like this, it's unlikely that either party will go to a court, but nonetheless, it's a question that you have to ask yourself. So if it's, let's say, competition law rules, you have a contract which will share the market within the European Union, or drug trafficking, or whatever illicit activity, then the question of advantaging one party does not come into place. But it is nonetheless a rare occurrence. So what I am saying to you, and I would like to conclude with that, to give the floor to Franco, is that Iura Novit Curia has some limitation beyond due process. Thank you.
Well, thank you very much also for pointing out the issue just referred to, meaning the issue of partiality. As the book that was referenced by Raphael shows, there are indeed cases where the choice by the arbitrators actually not to refer to a given interpretation of the contract, but to refer to case law on the issue pleaded by the parties has led to a challenge because, as Philippe mentioned, indeed, reference to two Supreme Court cases in that respect led one party to actually become the award creditor and the other one to lose the arbitration, which then in court led to a challenge. So all of the things are important. You have seen how many differences exist, even in relation to very close countries, neighboring countries like France and Switzerland, where the issue, of course, seems to be dealt with in a completely different way. I wonder, before we conclude, and we have still time, we know we have to stop but shortly, but I wonder whether any of the panelists would like to make a comment on what was said by the other colleagues. Sui Yen, do you have a question or a comment to make?
I do, because what I found Philippe said was very interesting, that as a tribunal, when you are faced with submissions from both parties, and if the proper breach should be treated as a particular clause, and none of the parties have raised it, should you, in that situation, ask? And I think I have found myself, when I sit as tribunal, in that sort of situation, and I tend to take a more cautious approach. So I would say, I wouldn't directly ask. I think that's usually what I do. I tend to be more cautious, but that is certainly something which I think tribunals should pay attention to. It is not an easy call.
I wonder, of course, whether there is a last moment in time when, as a tribunal, you should at all raise any issue. I mean, why do I say that? Because, for example, you, Sui Yen, said something may come up during the evidentiary hearing. One of the arbitrators finally wakes up and he or she thinks, oh, great, there is one case I know of, probably the only one I only know of. Is it still possible? I mean, are post-hearing briefs sufficient to guarantee the rights we have just heard? That should be guaranteed. Any views on that?
Well, I would say that if it's raised sufficiently in advance and you have a post-hearing, you're probably better off than not even raising it and having it in deliberation. So that will probably be safe enough in most jurisdictions, unless it's a crucial point. Yes.
Great. Unless really there are any comments, I would like to thank, of course, Azel for inviting all of us to be part of this event on The tribunal knows the law. I thank all of you for being part of this. And I would like to remind the audience that you can continue the conversation after this recording will be aired. Thanks to everybody. Thanks to the speakers. Thanks to the organizers. I hope to see you soon.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you.